the development of common law, I will first be explaining what is common law in the first place. Common law is the system of law which is common to the whole country, and it's a body of customary law derived from a number of past judicial decisions and embodied in reports of decided cases that have been administrated by the common law courts of England since the Middle Ages in the King's Court. It could also be used by the law that is not indicated by the Parliament. Okay, now that I've explained what is common law, I will be talking about the origins of common law. Common law originated with the help and support of the adversarial system in historical England from judicial decisions that were based in traditions, customs, and precedents. The adversarial system is a model of justice system which involves two lawyers representing the plaintiff and the defendant in representing the case, while the judge sits to hear and determine the issues raised without leading the discovery and presentation of evidence, which is the process that occurs during the inquisitorial system. Okay, now I will be diving into what happened before and after the Norman Conquest. Before the Norman Conquest, English residents, like those of many other societies, were governed by unwritten local customs that varied from community to community and were generally enforced in an arbitrary manner. During this time, the church played a big role in the government to implement its own laws and courts in judgments. After the Norman Conquest, which happened during the year 1066, during the reign of King Henry II, his circuit officials returned to Westminster following their trip around the country, with the findings that the administrative justice of church and the state were not in alignment with each other. And so, while sitting in the Westminster courts, they created rules of law leading to the creation of a set body of rules based on local custom conditions and are subsequently uniformly applied throughout the whole country.
Now we're going to talk about the development of equity. The English Chancellor relied heavily on the common law, but would do what his conscience perceived was morally right, where the common law would cause hardship in a particular case. The common law courts gave only common law decisions, and they did not have the equity jurisdictions. The Court of Chancery did not have the right to interfere with the common law judgment or change the judgment given by the common law courts in order to give a fair result to the litigants. And because of the problems of the common law, such as inflexibility, the concept of equity had begun in the mid-17th centuries. And here's the definition of equity. It refers to fairness and justice. Equity is a flexible application of broad moral principles to fact-specific situations for the sake of justice. Equity was also by now a central consideration for English lawyers, providing the basis of jurisdictions of the Chancery Court, initially conceived as a chamber within the King's conscience. In the person of the Chancellor, might be exercised to restore justice where the common law courts had failed. Now we're going to talk about the Court of Chancery. The court was doing equity, justice, and fairness, and was known as the Court of Equity. The Chancellor would decide cases on principles of natural justice, fairness, and good conscience, rather than the customs and precedents that were decided previously. It was headed under the Chancellor was established, which operated under the rules of fairness or equity. It was originally an administrative body under the Lord Chancellor, which became a largely judicial body in the 14th centuries, which further developed the doctrine of equity. and as a court of equity, in which character alone it was of paramount importance, owned its jurisdictions in the first instance to the practice of persons who thought themselves aggrieved by the law administered in the original courts applying to the Lord Chancellor. Now we're going to talk about a really important case, the Earl of Oxford case. It is a really important case because it talks about the conflict between common law and the equity law, and it demonstrates how fragile and susceptible equity was to political upheaval during the 17th centuries. And the King James I, on the advice of the Attorney General Sir Francis Bacon, ruled that in a case where there is a conflict between equity and common law, equity shall prevail. And this was a major victory for equity law.
Hey guys, my name is Jia Hui. So today we are going to discuss about the Judicature Acts, equitable remedies, and also maxims of equity. Starting off, we are going to discuss about the Judicature Acts, which is enacted by the Parliament. It discusses about the relationship between common law and equity. It allows single court to administer both the law and equity together. While the Judicature Acts are recognized and enforced, and equity given the preference in power, there is expressed preference by the courts to the existence of the two systems of jurisprudence and allusion to the distinctions between these systems, so that no one could prove by them that law and equity were fused. Next, we are going to discuss about the equitable remedies. There are 5 types of equitable remedies. Starting off, we are going to discuss about injunction. Injunction is a court order directing a person to stop doing that which she should not do. Next, specific performance is a judicial order to the promisor that he undertake the performance to which he obligated himself in a contract. Specific performance is a remedy that compels a party to execute their contractual duties when financial compensation is inadequate. This can be found in cases for private nuisance and also trespass. So specific performance is an alternative remedy to damages and may be issued at the discretion of the court, subject to a number of exceptions. The court's decision to grant specific performance depends on several factors, including the presence of binding contract, a breach of contract, the inadequacy of damages as a remedy, the potential impact on the defendant, and whether the contract was unconscionable or the claimant engaged in misconduct. Rescission is where the right in equity to rescind is the right of party to set aside a transaction and to be restored to their former position is a remedy for misrepresentation or for common or mutual mistake. Rescission for breach is available where one party accepts the other's representative breach. A representative breach is where a party fails or refuses to perform an essential or fundamental term of the contract, and it is taken to have decided to set the contract aside. The party who is not in breach can elect to continue the contract, claiming damages for the breach, or to accept the representative breach and to treat the contract as at an end. Both parties are discharged from further performance of the contract. A secondary obligation on the defaulting party is substituted to pay monetary compensation to the non-defaulting part of the losses sustained by reason of the breach. Also, ratification involves the correction of a mistake and which prejudicially affects the title of a registered proprietor. Also, the accounts of profits is when a person in a fiduciary or other relationship to the claimant improperly receives profit or withholds money or property from the claimant. There are various types of maxims of equity. Today we are going to discuss about the three types of maxims of equity. Firstly, equity will follow common law unless there is a good reason to the contrary. So where the law is not providing proper justice to the parties, equity is there to fill in the gaps and provide proper justice. So where there is common law and equity, then equity will prevail. Secondly, there is no wrong without a remedy. Wherever a wrong has been committed, equity will always provide a remedy. It is from here that the principle of always providing a remedy for anyone whose legal rights has been infringed. Hence, equity will always provide where a legal wrong has been committed, not where a moral wrong is committed. It is also thankful to this maxim that the development of new equitable remedies is possible. Lastly, where the equities are equal, the earlier in time prevails. Where the rights of the parties are equal both in worth or value, the one who comes first shall prevail. Hence, this follows the concept of first come and first served.
Hello, my name is Jun Fong, and I will be presenting the role of superior courts in developing precedent. Firstly, it is important to note that there is three types of precedents, which is the original precedent, where a new precedent is formed as there is no case similar to base a decision on. This is applicable to all hierarchy of courts. Secondly, we have the binding precedent, which is one that must be used in following cases that comes after if the facts of the cases are similar with the higher or equivalent court. And lastly, we have the persuasive precedent that contains various factors that can influence a decision in which can be followed when there is absence of binding decision, as there is no compulsion on the courts to do so. Now, the importance of the superior court is that they are able to set a precedent that is followed after by lower courts, meaning their decision in a certain case will most likely determine the result of the case in particular, unless there is a significant difference in material facts to that of the original case in which the precedent was set. In the article of Precedent and Rule of Law by Sebastian Lewis, an obligation of later courts to follow precedent applies when the precedent and present case are legally the same. However, whenever their similarities are relevant for the part of the law, while their differences are not, conversely, these two cases are legally different. A later court can therefore distinguish. In other words, the obligation of later courts under the authoritative mode has disjunctive form. This is to either to follow or distinguish the precedent. By distinguishing, later courts may show novel facts not shown by the previous precedent and is legally relevant for handing down a decision. The authority of higher courts also allows them to reverse the original decision made by lower courts through appeal, as they may disagree with the legal principle that was applied by the lower courts once they feel that the law was wrongly interpreted by them. Furthermore, superior courts has the authority to overrule a precedent in which they decide not to follow an earlier precedent that was set by lower courts, overruling the previous precedent as they are not bound by it. This can have a significant impact on the outcome of the case, as decisions that has been made by higher courts will mean that lower courts are inclined to follow them. When material facts are not similar or that precedent made previously by lower courts can be overruled or reversed. For example, in the case of Plessy v. Ferguson, 1896, this case established the separate but equal doctrine for racial segregation. This meant that facilities for black and white people could be separate as long as they were equal. However, in Brown v. Board of Education, Topeka, 1896, the Supreme Court overruled the precedent previously set by the case of Plessy. finding that segregation in public schools was inherently unequal and violated the 14th Amendment's Equal Protection Clause.
Hi, my name is Chloe, and today I will be presenting about the role of the inferior courts in making judicial precedent. So before we delve into that topic, I will first introduce to you the inferior courts and briefly talk about what they do. So for the criminal division, we have the Crown Court, and below the Crown Court, we have the Magistrates Court. So the Magistrates Court, they usually hear cases for summary offenses and not so serious, triable either way offenses. They also hold pre-trials for indictable offenses, which will later be transferred to the Crown Court. And talking about the Crown Court hears cases for more serious, triable either way offenses. So for example, burglary itself is a not so serious, triable either way offense. But if it's a burglary that involves physical violence, it becomes a more serious, triable either way offense and will be first heard in the Crown Court instead of the magistrates. So besides that, they also hear cases for indictable offenses that have been transferred from the Magistrates Court. So that's for criminal. For civil division, we have the County Court. The County Court hears cases regarding small claims, fast-track claims, and multi-track claims, and usually these involve contractual claims, tortious claims, could be issues regards to inheritance, or sometimes even family issues that are not too serious. So these courts, the Crown Court, Magistrates Court, and County Court, they are also known as the courts of first instance because these courts are where cases start. They are where they originally are heard for the first time. So yeah, moving on. Now we can talk about the role of these inferior courts in making judicial precedent. In simple words, they don't make any binding judicial precedents because they are not equipped with the power to do so. So they have to follow the decisions made by courts that are above them in hierarchy. So the appellate courts are also known as the superior courts, such as High Court, Court of Appeal, Supreme Court, or formerly known as the House of Lords. Any decision made by these courts, the inferior courts have to follow. So the most that these inferior courts can form are persuasive precedents, which the name suggests that it is only persuasive, it is not binding. So although I did mention that these inferior courts are the courts of first instance where cases are first heard, they still rarely ever make any binding precedents because it is so easy for a superior court to overrule any verdict that an inferior court might make. So with that being said, inferior courts are unable to make unable to make any binding precedent, which means that these inferior courts are not bound by their own decisions.
When it comes to judicial precedent, there is a lot of advantages that you can point out, and I'm going to elaborate a few of the many things. Number one, certainty and consistency. When a superior court held a decision, the inferior court have to follow it. This will provide consistency and predictability, and this will be beneficial when there is a similar cases because you can predict the outcome early on, and this will be beneficial to the solicitor and also the client because the solicitor can give advice to the client on what's what and what will happen. The solicitor can give a clear advice, and also the client, they will know what will happen and they can save themselves from a potential embarrassment because just imagine bringing a losing cases to a court. The client pursue the cases and want to bring it to the court and it's a losing. It's a very shameful consequences and you can avoid it by following judicial precedent. Number two, flexibility. Judicial precedent allow the court to interpret the law based on an evolution, because you cannot bring up a law coming from a case back to 1800 and apply it right now, because the world will go down. It'll be chaos. So with judicial precedent, the court can interpret the law based on what's happening right now. And this is also will provide a growth in legal principle and the doctrine of it. And also, court can depart from a case when there is an exceptional circumstances. Without judicial precedent, the law will be rigid, because you have to follow what is in the statute. With judicial precedent, when there is an exceptional circumstances, the court are allowed to depart from the decision that coming from the superior court. So the decision can be fair and just for both parties. And number 3, my point is effort is safe. Money, time, effort, you can save everything with judicial precedent, because there is an established guideline on the cases, because you know what will happen. You can see it on the law report. You can see what will happen. So with judicial precedent, you can follow the guideline and save your time. You don't have to make a research for it, study for it. You just have to follow the guideline. And also it will reduce the backlog. Just imagine all the cases in the waiting list of the court, the cases that want to be heard to the court. With judicial precedent, the cases that are similar from before, they don't have to wait on it anymore, because you will know what will happen. This will reduce the backlog of the waiting cases. And also, you can save your money with not having that many consultation with a lawyer, because you know what will happen and what's what. So you need only a few consultation from a lawyer. Money, time is safe, and also effort. That is all from me. Thank you.
Hello, my name is Lee Anson, and today I'll be talking about the disadvantages of the judicial precedent. Judicial precedence ensures consistency and predictability in the law. However, it has some significant drawbacks. This includes rigidity, complexity, and slowness of growth. The first disadvantage I will talk about is its rigidity. Judicial precedents are inflexible due to adherence to previous decision and judgments. For example, prior to RVR in 1991, courts consistently upheld the martial rape exemption based on older precedents like RV Clarence in 1888. This rigid adherence prevented courts from recognizing and correcting an injustice that lasted for centuries. The impact on this is that this prevents the law from evolving with societal changes, as constantly following the judgment of past cases may cause unjust outcomes to the current social norms. The second disadvantage of judicial precedent is complexity. Judicial precedents follow vast and diverse case laws that are from various courts over centuries. For example, the Human Rights Act 1998 incorporates the European Convention on Human Rights into UK law. Courts must interpret domestic legislation in a manner that is compatible with the Convention, as interpreted by the European Court of Human Rights. Balancing the principles established in case law with statutory provisions can be complex. Courts must spend a lot of time to ensure consistency in legal interpretations while respecting both statutory language and judicial precedent. The impact on this is that legal research would prove to be very time-consuming and difficult, as there are a lot of cases to go through to find relevant precedents. The amount of volumes and cases, and to be able to distinguish obiter dicta and ratio decidendi proves to be challenging to go through, particularly if there are a number of reasons. For the third disadvantage of judicial precedents is slowness of growth. Judicial precedents develop gradually over time through successive court decisions. This evolutionary process can be slow and cautious. For example, cases like Google Inc. versus Vital Hall in 2015 highlighted the struggle to adapt privacy laws to the digital age. Courts have had to reinterpret existing legal principles on privacy to address new challenges posed by digital surveillance, data breaches, and online privacy concerns. The impact on this is that precedents may lag behind societal developments, leading to legal principles that are outdated or inconsistent with current values. Slowness in legal evolution will cause injustices and inequalities to continue, especially for marginalized groups seeking protection and legal recognition.